Councilor Meshna can come forward. SJC-11618, Ron Meshna and others, the Scrivano Group, and another.
Good morning. You may proceed.
Good morning, Your Honors. I'm Shannon Liss-Reardon for the plaintiffs. In this case, employees have been subject to punishment, even termination, for exercising one of their rights under the wage laws, which is to accept tips that customers want to give them. Now, in this case, defendants, if you look at the statute literally, defendants have deducted from tips given to employees because they would have received tips were it not for the employer's policy not to allow them.
So are you, I'm a little confused as to the thrust of your argument. You're saying that that in an industry such as one that has individuals working there who fit into the definitions of whatever, those two, service providers and wait staff, and in such an industry, you cannot, as a matter of law, have a no tips policy?
Yes, that is what I'm saying. Both the letter and the spirit of the tips law provide for. Now, in 152A, Section G, the statute provides that an employer cannot, by special contract, exempt itself from the law. Essentially, this is a special contract, which is unusual in a restaurant, that wait staff would not be allowed to accept tips. In fact, it's built into the tips law that wait staff are expected to receive tips because the separate definition of service employees, you have to look at whether or not it's an occupation that customarily receives tips, but the legislature has recognized that inherently wait staff are customarily tipped employees.
Well, you say that, but you don't customarily tip people at McDonald's or Burger King. Is fast food different from slow food?
Well, I would say that customs evolve, and in recent years, going back a number of years, tipping in coffee shops is quite common. In fact, you can even tell from looking at this case that this employer does have tipping at many of his stores. There's just a subsection of the stores that he's decided to impose a no tipping policy, even though customers, the record shows that customers want to tip, would have tipped, are even upset about a policy that's trying to prevent them from tipping the wait staff.
Oh, sorry, go ahead. Finish your sentence.
The legislature in Massachusetts has recognized the importance of tips to the compensation of workers, and wait staff in particular, one of the lowest paid segments of workers in our economy, by receiving tips can have their wages boosted substantially. And the legislature of the Commonwealth has decided to give that special protection so as, unlike many other states, so as to even recognize tips as a form of wages.
So this isn't a case where people aren't being paid minimum wage. These are circumstances, unlike other circumstances where you get the boost from the tips. You are, if I understand correctly, you are looking at this, the words of the statute that preclude deducting, receiving or deducting. And you're saying that's deducting not from actual tips that were given, but that might have been. Am I getting that?
Well, there are a
Could
couple
you
of ways. There are a couple of ways
tell me what that
you can look at the language. I mean,
I did look at the language. I'm asking you to
right.
tell me what you mean.
So as the Dunkin' Donuts amicus brief says, Section 152A prohibits deductions from tips given to employees. Essentially, this policy has been deducting from tips given to employees because these employees are not getting the tips. Now, you can look at the language because the language actually says a deduction from a tip given to an employee. And to read that differently from how I just said it, the policy deducts from tips given to employees, I would submit would be the type of overly literalistic reading of the wage law language that this court has rejected in past cases. And for instance, in the Di Fiore case, the federal court had looked closely at the placement of commas to determine that non-employers were not subject to the service charge provisions of the law. Or in the Cook
It
case.
says tips given to or received by. And in this case, the employees never received the tips.
That's right. That's why I'm focusing on tip given to.
Well, it wasn't given to if there's a no tipping policy.
Well, that's right. But what if you, as I said, if you read the language as the Dunkin' Donuts amicus have said, what 152A prohibits is the deduction from tips given to employees. This is deducting from tips given to employees because employees are not receiving
But it hasn't
tips
been
based on this
where
policy.
is it given? That's.
Are you saying that because efforts were made from time to time by various customers who just left the money on the counter or, insisted that even notwithstanding the no tipping policy that they understood was there, they tried to tip? Are you saying that that is evidence that tips were intended?
Yes. That as well as.
By
Excuse me?
everybody that went in there?
Well, if you look at the custom in the industry, and in this particular industry, the custom is when money is left on a counter for counter staff, those are tips. And in fact, the tips law refers specifically to counter staff.
It's okay.
So unless it is very clearly disclosed to be something else, like for instance, a charity box. Now, we're not saying, plaintiffs are not saying in this case that employers must encourage tipping. We're just saying that a policy that prohibits tipping is, first of all, under 152A Section G, a special contract, not usual in this industry where tipping is customary. But if you had to say a charity box and customers knew that money was going to charity, that very well may not be a tip. But when customers leave change on the counter at a coffee shop in our culture, that's a tip.
I get that part, but I didn't think you were arguing the money that was left on the counter and then was pulled and put in a tip cup to be later dealt with, and you're saying inappropriately. I thought you were saying things that weren't left but might have been left meant that they were anticipating an amount, and the anticipation of what might have been left but wasn't, because they were precluded from doing it, is a deduction.
Right. Well, in this,
Is that what you're saying?
Well, in this case, let's take it step by step. There are three different scenarios that are presented by this case. The first one is where customers left money on the counter and then pursuant to the employer's policy, the waitstaff had to put the money in the register.
Correct.
There can be no question that that's a violation of the tips law. That was money left as tips and the employer took it. The court below agreed with that. Now, the second scenario is there's money that customers hand over, but the employees have to hand it back if they're able to, because pursuant to the employer's policy, they have to try to give it back. That's also a deduction from a tip that was given to that employee. Again, I think that scenario, there should be no question under the tips law that that would be a violation as well. Now, the third question, which I recognize is a little more on the line, but what is the focus of our appeal, is that money customers would give if it weren't for the no tipping policy is deducting from tips given to employees. So again, there are two ways to look at it. You can look at what I would submit this court would deem, or has deemed in past cases, to be an overly literalistic reading of this statute, which because it says a tip given to an employee, rather than it prohibits tips given to employees, I would submit that that is a violation of the letter as well as the spirit of the statute. Again, because an employer here is trying to exempt itself from the requirements of the statute by saying, look, we're just not even going to deal with tips. No tips are allowed.
But that's only if we accept your interpretation as to the third premise, that that is what the legislature intended when it wrote what it wrote.
That's correct. And there are other indications that the court can look to. For example, the fact that there have been recent attempts to amend the tips law to say that nothing in this law shall prohibit a no-tipping policy.
That's not what we usually look to, though, to inform what the legislature intended by what it did enact, right?
It is, I would submit that it's some evidence. And then another thing that I want to point out is that we're not saying in this case, this is not the case in which there is something in lieu of a tip, for instance, a service charge, so that traditionally tipped employees are getting some gratuity, but the employer says, no need to tip because a service charge is included or because a gratuity is included. Now, many of the ills that have been submitted by the amicus, for instance, the Seyfarth Shaw amicus brief, could be handled very well by what is in fact customary for places like resorts and clubs and other such types of employers. More and more are, in order to reduce what they consider to be the hassle of tips for their patrons, they say no need to tip because we include a gratuity. And then they actually do set it up so that the charge includes that automatic gratuity, and the employee's wages are boosted by that, and then the customers can rest assured knowing I don't need to worry about this because they're already taken care of. In an occupation in which it's customary, where customers want to give tips, they want to make sure that the employees are tipped.
So are we, if we accept your version of what the statute means, then are we inviting trials on whether X industry is one which is commonly one where tips are given, or Y industry, and that's what the fact issue is?
Well, you don't have to get to that here, because here we're dealing with wait staff who are defined, they're counter staffs. They're already defined in the law to be these protected employees. A case that's more on the edge as to whether or not employees are service employees, I mean, to be honest, those types of questions are already being litigated in the courts based on whether or not certain employees are entitled to coverage over the law. So this holding would not be what would create such uncertainties, and those issues are being sorted out by the courts now in these types of cases.
Dunkin' Donuts is like McDonald's, and these are also percolating up to our courts from McDonald's.
Well, I mean, McDonald's is a restaurant. If I believe
Counter staff.
with counter staff,
No wait staff.
if customers leave change on the counter at a McDonald's, I would submit that's a tip. Now, also, and I would submit that this court would also not allow a McDonald's employer to take change left on the counter and put it into the register. Now, what the Seyfarth brief says is that many of their clients have no tipping policies, and they try to announce to customers that tipping is not allowed, but when the customers go ahead and tip anyway, they let the employees keep them, and that's the right result. There's no hardship on the employer. This is a statute that the legislature enacted to protect a certain type of employee, and in the wait staff industry, particularly low-wage employees, in order to, at no cost to the employer, boost their wages. Now, if
The employer changed that policy here, requiring whatever was left to put it into the register, is that still in effect with this employer's companies?
well, what's explained in the record is that after the lawsuit was filed, the policy was changed such that they put out these little cups that they called abandoned change cups. And at the beginning, customers didn't know what they were. They looked to them like tips cups, and the cups were overflowing with change. And there's evidence in the record that then the employees were told when they started overflowing too much, put it in the register. After a while, according to the record, customers were not using the abandoned change cups as much. They might have gotten the message that they weren't actually going to the employees, and so they weren't leaving the money there. So I would submit, it's also not uncommon at counters to see the little take a penny, leave a penny container. If it's clearly labeled and customers who leave their penny there don't think the penny is going to the counter staff, I don't see a violation there. But if it's unclear what's happening with it, as it was apparently in the early days after this policy change, then I would submit that that's a violation as well. If customers think that they're tipping the employees, the money has to go to the employees.
How could a customer think that if they were told that there's a no tipping policy?
Well, another point that I want to raise is that in the statute, There's a separate section, 152A-B, that relates to tips, voluntary money left by customers, and another section, 152A-D, related to service charges, which are amounts that are imposed by the employer. So now 152A-D, the service charge provision, contains a section that specifically says that if an employer discloses that a charge is not a service charge, it doesn't have to be distributed to the employees. There's no similar section for the tips section, 152A-B, that allows that type of escape hatch from the statute. So I would submit that the statute does not allow employers to evade ensuring that employees receive tips by telling customers that they're not tips. But in any event, even looking at the service charge, even if the court were to adopt the service charge language here into the tips section, the disclosure needs to be in writing, for one thing. Oral disclosures have not been held to be sufficient in order to notify customers that something is not a service charge, which is understandable because oral disclosures are never going to be consistent and be able to be depended on. Make a big deal in this case that the employees told customers these aren't tips, or we're not allowed to take tips, but people were leaving tips anyway, so which raises another important issue that if
I think
customers are told...
your time is getting up, so...
Oh, okay. I'll finish this sentence if I may, Chief Justice. If customers are told we're a no-tipping facility, but they insist on leaving tips anyway, I would submit that the employees should be allowed to keep the tips. It's not... Employers cannot legislate, employers cannot impose a rule on their customers. This is a rule they're imposing on their employees, which again is subjecting their own employees to discipline for exercising their rights under the wage law, which is to accept tips that customers want to leave them. Thank you.
Good morning, Your Honors. Diane Saunders, and with me is Andrew Sylvia. May it please the court, before I start my argument, I just want to clarify a couple of factual issues that came up with my sister's argument. First, these are not tipped employees that we're talking about. All of the plaintiffs in this case made $8 or $9 an hour.
That's not the, right, I mean, that's not the criterion for whether or not an employee
No, of
is
course not, Your Honor. I just wanted to
protected
clarify.
employee, right? I mean, whatever they're paid otherwise is not salient to whether or not they're a protected employee under the Wage Act.
That's right, Your Honor.
Okay.
I just wanted to clarify because Justice Duffley had asked that question and just wanted to make sure that everyone understood we're not talking about tipped employees
But
here.
if they were a tipped employee, they would have a lower minimum wage?
We'd have a whole lot of problems here.
$2.63 or something like that?
Yeah, I think that's exactly right, Your Honor.
But is there a word in the statute that categorizes people as tipped versus untipped employees?
No, Your Honor.
People are wait staff.
Exactly.
And they're wait staff because they give prepared food directly to a patron.
Yes, Your Honor.
Okay.
Yes.
Before you get all warmed up to be discussing the issue of whether they can do a policy, if they can do a policy, must it be clearly communicated to the customer?
Your Honor, we submit that no, there is no requirement that that happen.
Well, if that's the case, then let's assume I go to a fancy restaurant, which quietly has a policy in the employee manual that says we have no tipping, but of course no one knows that because it's a fancy restaurant, and one leaves the usual tips. Can the employer then say, well, we have no tipping policy, that money is ours?
Well, I think that that's a completely different scenario than this case. So this is a case where there previously had not been tipping. So to Justice Hines' question, which I thought she was asking, there wasn't a change in policy here where there was tipping and then they instituted a no tipping policy.
But
There
let's-
is-
there's no tipping, but if it's not announced, that's
If it's not
Justice-
announced, you have the situation of McDonald's, Burger King, Wendy's,
Right, but
Subway,
isn't- but
all of these
doesn't-
national chain
Doesn't that
restaurants.
allow an employer to end run the requirement that the employer cannot keep tips by simply quietly having a no tipping policy and then keeping the tips that people leave not knowing of the policy?
No, Your Honor, the TIPS law we submit was not enacted to regulate what an employer can do with its customers and whether or not an employer needs to allow customers who are invited into the establishment as a guest to do whatever they want. And in this case, tipping. The employer has a right to decide that they do not want to allow tipping, that they're going to pay their employees minimum wage or above, and they're not going to ask their customers to subsidize the wages of their employees by tipping.
But if the customer comes in, and that's your policy in your head, and your employees know it from an employee manual, but I walk into Dunkin' Donuts and I don't know it, and I leave $1, do you get to keep it?
Well, here, Your Honor, the facts make the answer to that question very easy, because here it's undisputed that all of the plaintiffs verbally told customers that they weren't allowed to accept tips. That's undisputed.
But I thought you were arguing in your brief that in what Chief Justice Gans is asking, and I'm just repeating, that that's fine, you get to keep it.
Well, yes, and so I would go on. So I would say, in answer to your question, in this case, the answer is very easy, because the customers here knew very well, every single one of them, based on the verbal admonition they received from the customers, that there was no tipping. So any money that they left, they could not have reasonably expected that the employer would have then just disregarded its own policy that they were informed of and allowed its employees to keep the tips, even though they had been told that that establishment does not allow tipping.
They may assume that the employer is not a very nice employer and doesn't want its employees to have tips, but they're going to leave it anyway. That's a more likely scenario, isn't it?
They could do that. The testimony in this case is that the amount of money that was left was change, 5 cents, 10 cents, 25 cents, and not in the amounts that one would normally associate with tips to begin with.
Well, a cup of coffee is $1, $1.50.
When was the last time you bought a cup of coffee?
So
it's cheaper at Dunkin' Donuts, Your Honor.
You're not leaving $1 tip for a cup of coffee. You know, they want to leave whatever change is left over after the transaction, and that goes to the employee.
I don't think they're giving it to Dunkin' Donuts corporate coffers.
Well, Your Honor, first of all, there is another factual issue in the record. My client disputes that there was ever a policy of instructing employees to put the money into the register. That's what plaintiffs have testified. We dispute that. My client actually testified he instructed people to put it in the garbage, and then...
But in any event, somehow, well, okay.
We've been asked the question. We have certified issues.
Yes.
Here. One of them involves notice and whether or not that makes a difference as to whether the employer can keep the money. Right?
Exactly, Your Honor. And we submit that there is no notice that's required. The TIPS law neither prohibits employers from having a no-tipping policy. There's absolutely nothing in the language of the statute that says that. And the TIPS law does not mandate a disclosure requirement, although one is mandated in the administrative fee context.
Here's the obvious problem. Tips are left. If tips are left, whose are they?
Well, Your Honor, we submit they're not tips. It's actually abandoned change, because the customers in this particular case, and I understand Your Honors are looking at this more broadly, but even when you look at it more broadly, if you accept the notion that there is nothing in the TIPS law that prohibits an employer from having a no-tipping policy, then you can't assume that no customer could reasonably expect that if they leave money on the counter, that it's going to be treated as a tip. If you go into a McDonald's, just taking not my facts, but the broad facts, there's no signage in a McDonald's or a Burger King that says no tipping, and yet I've never seen anyone leave money on the counter, and a customer wouldn't.
What if they did? Thanks for that burger, here's $1.
Then it shouldn't be treated as tips, because the customer shouldn't have reasonably expected, given
Why not? There's no sign that says no tipping policy. I mean, sometimes you tip when you get coffee. Sometimes there's a tip jar out there, or maybe there might be in a McDonald's too.
Well, and I think that that's the triggering point, is the tip jar. What's customary in this particular industry, so unlike the fancy restaurant that Justice Gantz raised, in the fast food restaurant, even a a 7-Eleven or something where there is food and the counter staff may get something, I mean, you could even argue that could theoretically be wait staff. What's customary in that environment, if tipping is allowed, is to have a tip cup. And I would submit that a reasonable customer, if they don't see a tip cup, should not expect that tipping is allowed in a fast food restaurant. That is not a reasonable expectation for a customer to have. And
According to the industry, but I think that, according to the customers who are leaving the money, I mean, do we have a record that allows us to form a view as to what the customers thought was going on? I mean, I could easily see somebody just saying, you get 25 cents and change, and you just leave it there, or even being told we don't take tips, but the customer says, but it's for you anyway, and leaves. And why would a customer reasonably think that an owner gets to tell the customer what the customer wants to do?
because the customer is an invitee, Your Honor.
Well, you think
And
that's what the customer understands?
The business has a right to control what happens in its
Won't sell you
business.
coffee if you insist on tipping our employees?
They could theoretically do that. I don't think that that would happen, but it could.
I don't think it would happen either.
But my point is that the legislature, in enacting the TIPS law, went through and specified certain things that were and weren't prohibited, certain things that, didn't have to happen. There's no mention of employers not being able to prohibit tipping if they so desire. There's no mention of employers being required to provide some sort of notice, and particularly the type of written notice, signage that has been suggested should be required here. There's nothing in the legislature that says that.
What if we accept it, just for the sake of argument, that there is nothing in the statute that prohibits employers from having a no tipping policy? That still leaves the question, what if customers, and what if we don't accept that? What would you suggest would be the right thing in this case to do at that point with respect to the remaining issue, the stuff left on the table?
So if I'm understanding, Your Honor, so if the court finds that it was okay to have a no tipping policy, but the more difficult question, which of course is the second question, is how do you deal with the money left on the counter?
That's actually left despite notice that we have a no tipping policy.
Right, and Your Honor, I would submit that this court should hold the same way that the New York Department of Labor is held, which is pointed out in the New England Legal Foundation's brief, that money is not a tip. It is abandoned change, because those customers could not have reasonably expected or understood that the business was going to treat the change they left on the counter as a tip.
That's the problem I'm having. How do we get to the point where we conclude what the customers reasonably could have expected or not? How did that court get to that point? Was there evidence to that issue?
There isn't, Your Honor, but I think that this whole discussion of customer intent has been blown out of proportion. Counsel's cited some cases, prior cases, discussing customer intent, and they're in the service charge context.
From your point of view, what the customer could likely have expected if they leave it, we must assume that they, what?
I don't think there's anything in the TIPS law that evinces some legislative intent that customers and their intent control what happens in a business within the Commonwealth. The TIPS law was designed to regulate the distribution of tips that had already been left for employees who expected to receive them, because they work in an establishment where tipping is allowed, and those employees had a reasonable expectation of getting tips. They expected to get them to earn their income. So whether it be that they're a tipped employee or they understood that they were going to be getting tipped. Here, that's not the case. Here, these employees never expected to get tipped. They were hired with the full understanding that there was no tipping allowed, and these particular customers entered the store with the full understanding that there was no tipping. Whether they saw the signage, and there's a dispute in the record as to the signage, but the signage is really superfluous because it's undisputed that these plaintiffs here, verbally, every one of them told customers that there was no tipping, I'm not allowed to accept a tip. So the money left is not a tip. The TIPS law should be interpreted in such a way that the court is viewing the customers as reasonable people, not as unreasonable people who walk into a store and expect that even though they're told what the employer's policy is, that they're unreasonably going to overrule that policy.
Okay, the employer gets its wish. It has a no tipping policy. And customers leave money anyway. Why is the employer insisting over and above its no tipping policy that anything that's left is not a tip and therefore it doesn't belong to the employer? Why does the employer have to go that far if you get to say, we want a no tipping policy?
Well,
That makes it very hard for us to agree with you.
well, that's tantamount to essentially ruling that employers have to have a no tipping policy in Massachusetts, because if you
How is that
rule,
again?
because you'll be ruling that the customers and the employees, despite what the employer does in terms of having a policy, that they get to decide what happens with that money, and
The customer
they
gets
get
to
to.
decide whether they like the employer's no tipping policy or not. That's the point.
Well, their choice could be just not to come back or go to that particular establishment. They can go somewhere else. But there are many good policy reasons for not having tipping. So why would the employer insist on this and carry its policy to the extreme and actually enforce its policy and not let its employees have money that's left that they don't view as tips, or if you, Your Honor, views them as tips, is because there are a lot of good policy reasons for having a no tipping.
I guess your argument is if an employer can have a no tipping policy, then the employer ought to be able to enforce that policy,
Yes, Your Honor.
presumably by firing employees who accept tips.
Yes,
Still
Your
doesn't
Honor.
answer the question of the money left on the table, but.
Well, Your Honor, our position is it's not tips.
Well, it's just as unreasonable to think that people are going to abandon money.
Well, the amount of money that we're talking about here,
But
it's
I
not
mean-
unreasonable, because we're talking about less than $1. It's change. It's like a
Well, I
quarter.
wouldn't, I don't think,
Don't just leave 95 cents lying around on a table. Oh, well, it's less than $1.
so I'll abandon it.
Yeah.
Yeah, that strikes me as the most irrational explanation for the money put on the counter.
Your Honor, there is nothing in the statute that requires the money be treated as tips.
Don't you think the statute is animated by the concern that the right people get the money intended for them by customers?
For the right people who, when they join an establishment, are told that that establishment allows tippings, and they have a reasonable expectation of receiving tips. That's not the situation in this particular case, Your Honor. There's signage. The customers were told there's no tipping. And so, Your Honor, I don't think it's any more reasonable to assume that the money is tips than it is to say that it's not tips, where these customers unreasonably left change and, to your point, tried to tip when they were told that there was no tipping. That's unreasonable. And I think the law is designed to
Well, because the
reach
customer is always
unreasonable
right, is it
customers.
not? The customer's always right.
Yeah, but he doesn't always get what he wants.
Yeah, I guess that's right.
All right, with those,
Thank you, Your Honors.
we'll end on that. Thank you.
Thank you.